lead to things like criminal charges or something like that. But when people are not in harmony and therefore against each other, one of the things they may resort to is actually violence. Now, it is my view that people should see dispute resolution as an escalation. When someone is in dispute with another, the first thing you want to try and do is to avoid any form of escalation. You can concede if you know you're in the wrong, and therefore you avoid any feedback. Or you can negotiate, and we do this every day. We do this every day. I like to give the most simple example of when I see in Kampala, people are involved in a motor accident. The first thing people do is to get out of their cars. They may be upset. They may use strong language, but they start negotiating. Okay, how do we resolve this? And I think this is really the way to go. Or you may say, let me bring a third party into this equation and use that person who we both respect to help us to reach a decision. So this is all the staircase of ADR that I talk about. But since you spoke specifically to mediation, mediation comes in many forms. Mediation can be facilitative, which is basically you just facilitate the negotiation that is happening between the two people until you get a result. It can also be evaluative, where the mediator just does not give a platform for facilitating, but actually may give an opinion. And this is mostly what we are starting to see in quarter-next mediation, because they see that the mediators are judicial officers. So a lot of the expectation is, hey, what would happen if I went down this route? So you can do a quick evaluation for them that this is not safe. Perhaps it is better that you do the other. Or the third approach is transformative. You see, you want to engage in a negotiation that will transform the relationship between the parties who are in dispute. Transformative mediation, I can give an example, is very common in family disputes, where you want to build back a particular broken relationship. And you want to create a transformation either through a process of apology or through a process of forgiveness. So those are the various categories that you can come across. So that's, now how will that help us? One of the things that I would like to emphasize is that even though we say, and it is very common that people refer to mediation or arbitration as a form of alternative dispute resolution, that this is not necessarily true. Why? Because they are saying it is an alternative to litigation. And I think this is where the problem comes in, because litigation only came to Uganda very recently through the order in council. I believe it was 1906. And therefore, it has not been in Uganda for that long, probably just over 120 years. The question therefore arises that what was the practice of dispute resolution before the order in council, before the courts came into Uganda? And when we look at our African traditional justice systems, we actually note that there is a lot of similarity between them and what we call alternative dispute resolution, the ability to negotiate away a dispute, either with the help of a family leader, a clan leader, a religious leader, as the case may be. And we find that the difference there is that the result normally is a win-win situation. Whereas in litigation, as you know, it is a win-lose situation. Now, it is very rare that when you have a win-win situation, and there are instances where this does happen, I do not want to say they don't, but the instance of where you have a win-win situation, there's very little room for appeal, because what that process does is restore harmony between the parties. Whereas in litigation, the winner takes it all. So the loser will normally try, if they have the ability to do so, to appeal. They may go through a process that is a first appeal. They may go through a process that is a second appeal, and there is also provision for a third appeal. But what happens is that whereas in the first mode, you exit the dispute almost instantaneously, in the other one, you may be in the system of dispute resolution for many years, 10, 20, 30 years. We have seen all of this in the courts. Why? Because people are trying to change their fortunes through the process of litigation. And what do we see? We see that that is costly, that is time-consuming, that breaks further the relationship between the people who are in dispute, and it also presents a burden on the courts. Why? Because the fact that one court has given a decision does not mean that the parties have exited the court system. They're just putting it to another level of the court system. And the court system is, of course, its resources are limited, its personnel is limited, its presence, its footprint in the country is also limited. People have to travel long distances in order to be able to access these services. And also the mode of dispute resolution is also, should I say, complex. It's difficult to understand unless you have the help of an attorney, an advocate, as the case may be. Now, an organization called HIL gave a report in 2016 and 2019, which I think, whatever their methodology, whether you agree with it or not, is interesting for me. So, for example, in 2016, it said that only 5% of all Ugandans who are in some form of dispute, 5% will go to the normal courts. And of that 5%, only 1% will go to the courts with a lawyer. I think that's quite profound, because then you ask the question, where do the remaining 95% go? Where do they go to resolve their disputes? And even though we do run a noble profession, it is obvious, therefore, that our impact in dispute resolution in Uganda is not that big. It's actually negligible. If we closed the profession, the country will continue based on these statistics. Now, the 2019 report has improved the statistics a little bit and has said about 10% now go to the courts. But still, it means that 90% do not. Actually, it's not 2019, I correct myself, it's a 2024 report. 10% go, but even then you can see between 2016 and 2024, only an improvement of 5%. So really a critical study of this statistic will seem to suggest to me that people do not only use litigation to resolve their disputes. And therefore, if you are a young lawyer today and you seek to make impact, you want to be in that space, that whether it is 90% or 95%, if you're going to grow. You want to enter that space because that is where the business is. Even though we have case backlog in the courts, one can only but imagine if that 95 or 90% was also coming into the courts would collapse. It will not be possible, it will not be perceivable that even with this system, which is largely regarded as broken in the court system, that we could be able to absorb anything more than what we're absorbing today. And so really what I would like to suggest to everybody who is on this call is that we need to have a paradigm shift, a shift that moves us from just considering litigation as a means of dispute resolution. We need to go back, like that. I don't know, I watch movies, you need to go back to the future, or should I say, move back to the past and try and build on some of the synergies that have worked for us for a very, very, very long time. And so I know one of the challenges is that the training is small. We come out of a fairly colonial agenda education, which did not allow us at law school to really interrogate these other methods of dispute resolution. Actually, when you think about it, the law itself made it clear that we had to look at our own methods of dispute resolution with suspicion. And that's why we had the repugnancy clause, which said that customary law would have to be tested against this clause if it was to be applied in court, and custom had to be proved almost like you're proving a criminal case beyond reasonable doubt for it to be used. So I think that's what I can say to start off this discussion.
I think that is a very, very beautiful explanation of, first of all, the tenets of mediation, and also giving it context in the Ugandan sphere. Because I have actually had arguments with many young lawyers who are saying that, no, mediation is actually taking away our clients. We are not going to make money because they are used to making money from having, for instance, a case run for a span of maybe 5 years. And every time you're going to court, you're given fuel, and the more applications you argue, the longer the case extends, the more money you make. And I like that you debunk that myth, because you can actually make more money as an ADR practitioner, because you are delivering the quality of service and in a timely manner, and also the quality cannot be beaten, because who wants to wait 10 years to have a dispute resolved? My next question, Ms.
I'd like to come in on that one, that actually
okay.
ADR does not take away. It is actually true what you say, because some authors have written and said that lawyers worldwide review ADR not as alternative dispute resolution, but rather as acute deficiency in revenue. You see, basically pointing to the fact that if you go ADR, you are going to have a revenue shortage. But just looking at Uganda as an example, as I have said, only between 5 to 10% of the total population go to court. So why are you fighting in that space? that space is too small. That space is too small. You want to be in the bigger space. You want to be in the 95%. You want to be in the 90%. But our system is designed such that really it is a walk-in. It's a walk-in system whereby people walk into the law firm. And the people who walk into the law firm are those who have the ability to walk into law firms. But there are so many people out there who do not have the ability to walk in law firm, who are out there for you to pick and help and actually grow your business.
That is very true. So young lawyers, older lawyers, much senior lawyers, this is a very juicy space. Please come join us so that we can all make a lot of money while also serving the people we are meant to serve. Now, I would like us to talk about the shift in the law regarding court-annexed mediation. Initially, court-annexed mediation was governed by the Judicature Mediation Rules 2013, but with the amendment of the Civil Procedure Rules 2019, the pre-litigation mediation that was initially mandatory was ousted. So the question would really be that if judiciary is pointing into the direction of ADR, how can this be reconciled? The judiciary's commitment to promoting mediation as an essential tool in dispute resolution, and then the fact that it was pulled away from the mandatory nature. Your Lordship.
That is an interesting perspective. First of all, I've seen Felix, my old classmate, on the call. I'm happy that he's there as well. What I want to say is the introduction of mediation through the 2003, 2007, up to the 2013 rules did not come easy. It came with talkback. The talkback was not just within the bar, it was also within the judiciary itself. There was this feeling, and it came from a lot of, again, our training, that the courts really have unlimited jurisdiction. So if there's a dispute, bring everything to us, which was a misnomer because you couldn't handle everything. And therefore it was thought, and it was also argued by some counsel, because I have seen this in my practice, especially when I was at the High Court, that people were saying that using ADR was an attempt to oust the jurisdiction of the courts. This was an argument that was used. And it was quite interesting because they were not making progress in the courts anyway. You see, they were not making progress in the courts anyway. And still, so they wanted to wait their turn. But waiting their turn was a disservice to their clients because it meant waiting perhaps 2, 3, 4, 5, 6, 7 years, as the case may be. However, what happened is that because of this misunderstanding, it was believed that it was not good to have a process that was mandatory. The definition of mandatory in the minds of most people was that if you did not do mediation, then you would not be able to progress to litigation, which was wrong. Because anybody who's a student of mediation, when they talk of mandatory mediation, it is different from saying you must do it. What it means, because mediation is voluntary, and therefore it was mandatory to attempt, but it was not mandatory to conclude. And if you look at Order 12, if you look at the 2013 rules, there were timelines which would determine whether you had attempted it or not. So actually, mediation was not removed. It was just shifted. And what happened is that you had to go through this summons for directions in order to determine whether mediation should take place or not. Now, if you're a student of case management all over the world, when you're doing case management, it is important for you to know how many steps you need to go through the justice system in order to get a resolution. That is how all judiciaries in the world are evaluated. Now, those countries which have fewer steps are rated higher than those which have more steps. So in removing the mandatory mediation and putting in summons for directions, actually Uganda added a step and therefore affected its ranking internationally. But also, because all of this took place at the time of summons for directions, there was no incentive to try mediation at all. And so what did we see? We saw a drop in the uptake of mediation. By the time I came to the Court of Appeal, and then coming from the commercial court, we had a success rate of 25% of all cases filed. Now, someone may argue and say, oh, it is because those were commercial cases, they are easier to mediate. But I think the effect must have been the same in other divisions as well. There was a drop, a significant drop in mediations being taken up and therefore successes. But because we were able to have a 25% success rate when we were at the commercial court, it meant that we didn't have to hear those cases. There was 25% of the cases that were filed were removed from our docket. And that put the commercial case in a very, very, very respectable position, not just in Uganda, but also regionally and internationally. I think there is no doubt that many people use to refer to the commercial place as a very efficient and effective place to go for many reasons, not just mediation, but mediation being one of them. Now, what has happened is that new rules are coming out shortly. The new rules coming out, the amendments are going to reinstate, because I think this has already passed the Rules Committee of the Chief Justice. We're going to go back. We're going to go back to the 2013 position. But we're going to have, I think, more details to guide the parties when they come to court annexed mediation. And remember, at the time we were doing it at the commercial court, and I can't remember how many mediators there were in the other divisions. We had 19 mediators. We had 19 mediators. But right now, for countrywide, we have well over 90 mediators who are going to be part of this new mediation practice that is going to be in the in the judiciary. Now, I have seen some people are concerned about enforcement mechanisms. And probably this was not well articulated at the time mediation was being introduced. say, if you have an agreement, if you settle, then how do you enforce? Now, the idea is this, that if you have settled through mediation, the mediation should be self-executing. And the trick here is the skill with which you as lawyers will write the what? Mediation agreement. Now, the mediation agreement is then registered as a decree of court. And therefore, the court still comes in to assist where there has been default of a consent judgment. So I think we all know and must agree that one of the best judgments you can ever get out of a court system is a consent judgment. Why? Because if properly drafted, it is self-executing and will not require further litigation. Yeah.
Your Lordship, for the clarity. And you cover so many things, especially about the clarity provided about about the Judicature Mediation Rules 2013 and the Civil Procedure Amendment Rules. Also, you speak about the need for clarity in drafting of the mediated settlements, which would form the foundation of a proper execution of the mediation agreement. Now, I would go to the comments first. We've done 40 minutes so far. Time is flying so fast. Media Felix Bakanyebo says mediation is the way to go. Thank you, Felix. Vincent Bitature said, what is important for the vocation, money or peace or stability? Well, we need to decide as lawyers. Justice Shiriawire started interesting parties and advocates way back as a judge of the commercial court. Yes, that's why we call him the grandfather of ADR in Uganda. Let us revisit dispute resolution mechanisms that were effective for our forefathers and remain relevant. Ms. Namgera Sania, thank you very much. Wanzira Philip says, litigants are hesitant in appreciating ADR due to the lack of clear enforcement mechanisms of mediated settlements. For example, under the reconciliation agreement, we end up under Order 36 or small claims. I think His Lordship has handled that. Vincent Bitature says mandatory mediation didn't remove litigation, but merely gave an opportunity to cut on the case backlog in the event parties were able to resolve the disputes and much litigation because we were spending so much time in court. Anaklet Turiachiria says, one time I appeared before the honorable judge and he helped us resolve the matter. The settlement gave the plaintiff more money in terms of benefits that it had actually claimed, and even what the plaintiff company would have received at the end of the trial. He did joke that for him, he was a judge. He was a judge from the commercial sector. Thank you, Your Lordship, for pursuing alternative dispute resolution. Now, I will stop there with the comments so that we can go into the next set of our questions. And this time we are delving into appellate mediation. And I earlier on mentioned that I really had a problem understanding where appellate mediation stands in relation to the principle of sanctity of judgments. And my question to you, Your Lordship, is where does appellate mediation stand in the law, and what is its role in Uganda's judicial system today?
Right. Appellate mediation is a new layer that the courts have provided to dispute resolution. Those who have followed the history of alternative dispute resolution, especially in the United States, will have remembered the Pound Conference of the early 1970s, which really made a paradigm shift for the US court systems to emphasize settlement as much as possible as opposed to litigation. And I think that has largely worked in the US because I think less than I don't think more than 10% of all cases that are filed in the US end up with a judgment. They always find a way to settle. And I think the statistic is only 5% of all arrests lead to a trial in the US, which means that they're using these alternative means. For Uganda, the statistics will be in the reverse. And that's a problem. So what parties are interested in, those who come to you, is a resolution of the dispute that they are in with somebody. Now, it is possible to get that resolution via a judgment. So that settles the matter, and then people get on with the rest of their lives. However, the practice is that, and we're seeing a lot of this, that even with a judgment, the dispute is not necessarily resolved. So people will come on further appeal on that judgment. So it is not really done until it is done. And some people may have to go all the way to the Supreme Court to do what? To resolve their dispute via a final judgment from the Supreme Court. But even when you look at the Supreme Court, when you look at Alcon, for example, you can even have a case where the Supreme Court has resolved it one way, then it comes back and has a review of its own judgment later. But perhaps for this call, the most important thing that I can announce to those of you who are on this call is that this week, the Supreme Court formally started and launched its appellate mediation program. Therefore, meaning that appellate mediation has now reached the apex court in Uganda. And there are matters there which are being scheduled for appellate mediation. Now, for many of us, this was impossible to imagine. It was incredible. When the Supreme Court has spoken, that's it. But we are now seeing that appellate mediation is now across the full spectrum of the court system. And why is this happening? It is happening because the ultimate objective of the parties, is to close the dispute. There's a difference in my mind between closing the dispute and closing the case. You can close the case with a judgment, but you do not necessarily close the dispute with that judgment. And sometimes we have seen escalation as a result of judgment. And we see a lot of this in the land. You have a decision on ownership of land. It does not resolve the dispute, and it escalates into violence or murder, aggravated assault. and it comes back as a criminal matter. Because the way it used to work in the African justice systems was that it was not resolved until the person who was assisting in resolution of the dispute found that harmony had been restored within the community between the parties. And when you have harmony restored, then the chances of further escalation are minimized. But here we have a situation where you have a judgment, but the parties are not satisfied. In fact, we have judgments here in the Court of Appeal where not only do you have an appeal from the judgment, you also have a cross appeal on the judgment, which means both the winner and loser at the high court level are dissatisfied. So what does appellate mediation do? Appellate mediation goes below the line. In mediation or alternative dispute resolution, we have what we call the main line. You see, it's like an iceberg. What litigation does is just see what is on top of the water. But below, there might be a larger mass. So we go below the line and try and understand what is causing this problem. And those of you who are familiar with the conflict circle, you may find that it could be values, different values that are fueling the conflict. You may find that it is emotion that is fueling the dispute. You can find that it is standards that is fueling the dispute. I don't want to overemphasize my book, but if you read it, you'll get a lot of detail as to what the conflict circle is. It's very important to understand what is the thing that is accelerating the fire. Is it the petrol? Is it the wood? What is it? I'll give you one example. I think this is probably the best example that I have in all the appellate mediation that I have done. You have a family. You have a family, and this will be good for your association because they're Muslim, and they had two wives, but the second wife only had one child, a girl. And the wife was obtained later on in the man's life. Now, there was no bonding between the first set of children and this one girl. This is just what happened. And so when he died, he asked the heir to distribute the property. And the girl was not happy with the distribution that had been made. So she went to the High Court and said that she had been given a smaller portion of land than the rest of her siblings. And the High Court then decided that the property should be redistributed and all the children get, as far as possible, an equal amount of land. So the other part of the family came on appeal and said, no, this is unfair. And looking on the surface of it, one would wonder what is unfair about an equal distribution of property? What's unfair about that? Nothing. But through mediation, because we identified this file for mediation, and through a process of caucus, I will not go into the details, I was able to establish They came from Masaka. That this lady who had filed the case at the High Court was actually doing much better than her siblings. She was actually based in Kampala in Kawempe. And when I looked deeper into the problem, because when I looked at the record of appeal, it was pages upon pages upon pages. I had the feeling that this must have been about 1/3 or half of a square mile, given the amount of anger and fighting that they were going through. Actually, it turned out to be a 50 by 100 plot. And I was wondering, oh goodness, here's a panel of 3 people dealing with 50 by 100. Perhaps we should.
100.
But I think there must be better ways of using 3 justices of the Court of Appeals time than dealing with a 50 by 100 plot. I wouldn't like a Court of Appeal judge from the UK to sit with me in that trial as I had to resolve this. So I asked the Musika, the air, I said, what's this all about? And they said, oh, you see, our sister is difficult. She doesn't like us. We knew this. So what we did, we gave her, yes, it is true, we gave her a smaller plot, but we gave her the plot on the main road, which is of a higher value. And for us, we took the plots behind. So we thought that if we give her on the main road, she would be happy. But still, she was not happy. And now the judge said, give her more land, starting from the main road, which means that now she even has more value, which is unfair to us. Now, none of this was in the record of appeal. None of it was even in the judgment. And when I asked in caucus the lady that, what's this? You seem to have higher value. You're on the main road. You didn't even tell me that you're on the main road. It is at that point that she actually literally broke down. She broke down. She became very emotional. And it was clear to me that her problem was not the piece of land. Actually, she told me she had a lot of land which was bigger than that in Kampala, higher value. She said to me in not so many words that she was being disrespected. Even when one of the phrases she used was saying that, you see, even when we have a family meeting, they call me by WhatsApp. The rest they call on phone. And so in her mind, the best way to resolve this was to put pressure on them using the land. This is a true story. So we had this discussion with the heir and said, you improve your relationship with your sister. Take her to Masaka, reintroduce her to the clan. You just have a better relationship. And then come back and we have another session. I think it was 3 weeks. And 3 weeks, the lawyers showed up. I wanted to see how this had progressed. And I said, where are your clients? I don't see them in this mediation. And they said, oh, they're not coming. My first impression was, oh dear, this mediation has failed.
Has failed.
So I said, oh, okay, so have they exited? Should we close this file and refer it to trial? And they said, no, Judge, no, you don't need it. They have now agreed. I said, what have they agreed? Said, the sister says that now that she's being respected, she will just keep the 50 by 100 on the main road, and she will ignore what the court had given her in terms of expanding it. And we signed a settlement agreement and withdrew the appeal from the court. This, for me, is the best way to explain appellate mediation. She gave up the rights that the judgment had given her. She preferred it for peace and harmony within the family. Why would she otherwise not enforce the judgment that she had been given at the High Court? The answer is very simple, because she wanted to live in peace with her siblings. That is what appellate mediation is concerned, and it is in line with Article 126. It is in line with Rule 94 of the Court of Appeal rules. Now, we are in the process of amending the Court of Appeal rules, and we are going to provide more clarity around the subject of appellate mediation. Of course, there's always that big thing, what comes first? Is it the chicken or is it the egg? Should we first have the innovation and then have the rules, or should you have the rules, then have the innovation? My view has always been that you have the innovation first, and then you have the rules to support it. That's what we did with small claims, and we're able to achieve great mileage. So what we did in terms of plea bargaining, it's the same route that we used. So there is absolutely and totally no magic about appellate mediation. You can even settle in victory. You can settle in victory. You can be magnanimous in victory. It is possible. But also remember that there is a certain percentage of decisions that come to us that we reverse. We reverse. And so your victory becomes a loss.
Yes.
It is not done until it is done. And as I've also said, right up to the Supreme Court, you can think, you look at Alcon, you can think that you have actually won when you have not. You see? So the best thing is always to get out where there is some degree of harmony, not just legal decision making. You see, where there is some degree of harmony, it will work. And we have seen this across the board. We have seen appellate mediation being taken up by the government of Uganda with the Attorney General of Uganda signing off. So if the principal legal advisor to government is signing off appellate mediation, then there is value seen in it by those who represent government. And you know, government is one of the hardest people to negotiate with. So we have had that. We have had countless settlements involving the Uganda Revenue Authority. We have dealt with big, game, for example, that was sorted by us. The harm problem was sorted through appellate mediation. 7 years in the courts. But at the end of the day, it ended up going back to the table for negotiation. You see? So we've had it with the banks. We have had it in matrimonial matters. We have redistributed property during divorce in a manner that is more acceptable to the parties than what the trial court had decided. And therefore, we have brought to conclusion the dispute, which is always much better than closing the case. Now, the trick is this. There is no case backlog for mediation at the Court of Appeal. What am I saying? For us, we define case backlog as anything that has come to us and has not been decided upon within a period of 2 years. Now, we have appeals which are pending. We have actually 12,000 matters pending in the Court of Appeal, 12,000. And we try to do them on a first in, first out, FIFO, first in, first out principle. And so people have to wait for quite a bit of time. For a long time, we were oscillating between 9 and 13 justices of appeal. It's not possible to do that in a timely manner. But anybody who, I think the longest negotiation that I have seen has taken probably just under 1 year, and they're out of the Court of Appeal, either with a complete settlement or an agreement that it has failed and it should go to litigation. But right now, we have a 60% success rate on the cases that come in for appellate mediation. That is very high, considering that there is a judgment. That's a very high statistic, considering that there is a judgment. Actually, it is higher than what you're seeing in the High Court. So again, we debunk the theory that you cannot mediate when you have a judgment. You can. Actually, can even do it more successfully. The reason probably is that the judgment has given you a better insight as to what your rights are, what your obligations are, and what the options are. Yes, so appellate mediation is now the fastest growing registry. Right now we have pending about 160 matters in our registry. Now, considering that we didn't have a registry before, you can see that the filings are quite high. By the way, now we have stopped identifying cases because that's how we started appellate mediation. I had appellate mediation in the Court of Appeal, and our process was that we go file by file and choose what we thought was good for appellate mediation. Now we no longer do that because the requests for appellate mediation are too many. There are too many. So we have enough work in appellate mediation without having to look for the files which we think will work, will be in sync with appellate mediation. Almost every 1 to 2 weeks, we have requests coming in that look, our clients would like to consider appellate mediation. And I think we're seeing great progress in this one. If we can increase the number and maintain the percentage of success,
output,
then I think the Court of Appeal will be a totally different place. Why? Then we concentrate on the harder things. We concentrate on the things that really require interpretation of the law, provide greater guidance to the lower courts. We concentrate on the areas which have extremely complex facts, okay, that would need the justices to apply their minds, and ultimately improve even on the quality of judgments that are written. And if we concentrate on that, then the turnover will even be better because you have judgments coming out faster, simply because you're concentrating on those which need to be
your attention the most
addressed, not those which could be addressed. There's a big difference.
Thank you so much, Your Lordship. I think that pretty much explains what appellate mediation is, what it stands for, and the considerations. And it clears many of the questions that I think many advocates have been having about appellate mediation. Now, you mentioned very many nuggets. You keep mentioning harmony. And when I met you with Kevin Odoki, I remember you talked about harmony, and we kind of like had brainstorming about it. And when you mentioned harmony today, it just reminded me of the discussion. I would like for you to explain it to those on the call, because when we were there, we had the benefit of discussing harmony, and what applied law means, not just the law as it is in the statutes, but applying the law for the benefit of the parties you're applying the law to. Because it wouldn't be, like you said, it wouldn't be ideal for you for the court to put out a judgment, and even the person who would be the winner is very dissatisfied. The loser is dissatisfied, but even the person who should be celebrating is still dissatisfied. So, Your Lordship, I would like for you to explain harmony and applied law for the benefit of the participants.
Well, I think when we had that discussion, can you hear me?
Yes, we can hear you loud. Yes, we can hear you loud and clear. Can the participants hear him?
Yeah, okay. Right. I think during that discussion we had, you asked the question that what is justice? I think that is where this discussion came
began.
and yeah. And I think everybody on this call can take 10 to 20 minutes trying to define what justice is. Some would say justice is fairness and take a discourse down that one. Others will say justice is vindication of rights, and so on and so on. I suggested to you at the time, and I will suggest to those people who are on the call right now, that justice is not an event. I don't think you can say justice, someone has got justice simply because the matter has been fair. You know, for me, I think justice is a continuous destination. If you want to take an analogy with a train, it is like you're moving from one station to another. In the United States, it used to be legal to own slaves. And it was therefore within the law to mistreat the slaves, to treat them, in other words, as property, in spite of what the US Constitution provided for, that we declare that all people are born equal. And so vindication of rights for a slave owner would be legal, but in many ways, it will not be just. The women in the United States only got the right to vote in the last century. And that was legal. But today, everybody in the United States has universal suffrage. Everybody can vote. Slavery is an offense. But also, you can take another imagery of climbing a hill, and when you reach the top of that hill, you find another hill. So you keep, justice is something that continues to evolve. That's my understanding of justice. But more importantly, you cannot achieve justice until you have achieved harmony. And for those who are Christian on the call, you know that when God made the Garden of Eden, there was total harmony. And he said it was all good. That is the ultimate of justice until it was disrupted. So I think that even as we pursue litigation, even as we pursue dispute resolution, we should try and restore the harmony or the equilibrium that existed before the dispute as much as possible. You see, actually, that's the principle underlining general damages, that you try to restore as far as possible the person who has incurred loss. It's never possible. It's never possible. You just try. You just try to do so. So I'd like to suggest that it is easier to restore harmony and equilibrium as much as possible through the process of alternative dispute resolution, and especially mediation, as opposed to litigation. I think that's the discussion that we had.
Yes, it is the discussion that we had, but we kind of like, I noted it and I wanted you to share it for the benefit of the audience, because we are oftentimes we apply the law in a robotic way. We fail to understand, to give it a context, and it's like we're applying law in a vacuum. That's why we have persons who are winners in courts who are very dissatisfied. Thank you so much, Your Lordship, for that clarity. I would like to go back to the comment section. We have over 65 comments, and I would like to run through them very fast. Miss Isaac Namtevi says, actually, I have been a beneficiary of Supreme Court mediation. Oh, really? That is great. Mr. Wagaba Divya, it's a pleasure to be here. Yes, thank you so much. Ms. Namgara Sania says, Supreme Court has launched appellate mediation, and she's clapping for the initiative in innovation. Isaac Ampeire, indeed, appellate mediation is a game changer. Yes, it is. Susan Nambozo, appellate mediation any different from mediations conducted before appeal in terms of principle? I think you have answered that. Would you like to say something about it, Your Lordship?
No, actually, the principle is basically the same. It's basically the same. It is facilitated negotiation. So it's basically the same. The important thing, perhaps I need to add, but this will be going, and perhaps we can have another discourse on this. The nuts and bolts. Actually, how do you do mediation? How is it actually done? Because we're really dealing with the broad principles here. You must, there is something, there's a person called Yuri who wrote the book, Getting to Yes, Fisher and Yuri. I think everybody on this call should get a copy of that book, Getting to Yes. It teaches you how to negotiate. And there's the principle there called banter. Everybody should have their best alternative to a negotiated agreement. And it is through that that you enter the negotiation. And whether it is appellate, whether it is pre-trial, it is basically the same. It can be and I don't want really to go too deep into this. You can have distributive mediation. You can have something that is more value addition mediation. There are very many practical ways of doing this, but whichever approach that you use, it can be applied whether the matter has not gone to court, has gone to court, there is a decision of court, and the matter is on appeal. Yes, there are certain principles that help you do mediation better. And that is why I would really recommend to everybody on this call that they do take time to either do a course or a program on mediation. Right now at the Law Development Center, because I am chair of the Bar Course Advisory Committee there, we have started this year mainstreaming ADR into all workshops that are carried out at the Law Development Center. So we hope to get a better understanding as more people go through the training. But even if you have missed that training, there's absolutely no reason why you cannot do that either through CLE or actually further studies. There's also through the Uganda chapter of the Chartered Institute of Arbitrators, they also have programs on mediation that you can look to. Yeah.
Yes, and that answers one of the questions, the concerns I had, because there's a very big knowledge gap, and we wanted to find ways of addressing that because of the fact that very few institutions are providing the service. It is very costly, and so many members of the Uganda Law Society have not taken the courses. But I think we can have this discussion. We can continue this discussion. I will try to go through the comments. Family matters, George Wanka says family matters are usually so complex compared to commercial disputes, ego and feelings. Yes, that is true. Grace Akulo says lawyers must embrace mediation. That is very true. Colin Biaruhanga, 12,000 what? Oh, I think he was commenting about the number of cases that are pending before the Court of Appeal. Atuhaire says, at what point should counsel demand payment of fees? Clients be funny and fail to pay before the process, fail to pay process before they pay fees. So, Miss Your Lordship, would you like to comment about this? The participants are concerned about their fees if they partake in mediation.
I think ultimately the law council will have to enter this area of how to manage the issue of fees, and probably we could have an additional schedule to the advocates' remuneration and taxation of cost rules. But I think that the most important thing is I think there is no universal rule. I think it varies from practice to practice. How is it that you secure fees? But I can assure you that a quick disposal will give you a greater willingness for people to pay fees than something that is dragging on and on and on and on. I think that is a harder one to deal with. And I think law firms worldwide are now moving on to a more business model of practice, because you really need to have a business model for yourself, how you're going to run your law firm. Is it going to be 100% on fees? Is it going to be on turnover? Is it? I know there are law firms which even just enter particular areas, certain spaces on a pro bono, so that they can get visibility. Sometimes that is good, sometimes that is not good. Speaking as court administrator, we saw a lot of that in constitutional matters. So you create a constitutional matter that doesn't exist, but doesn't matter. I think your business model is important. The better your business model, the better your chances of recovery. Don't just practice without a business model. I think you need to have a business model that works for you, because it also depends whether your practice is in an urban area, whether it's in a more rural area, peri-urban area. Are you global? Are you local? All of this, the model will change. Are you affiliated to an international law firm or whatever the case may be? Yeah.
Thank you so much, Your Lordship. We are pressed for time. We were supposed to end at 4:30, and it is a few minutes to 4:30. So we are going to have to, I'll consider 2 comments here before we have His Lordship's closing remarks. I think this is a conversation that we need to continue because not everything has been addressed. For instance, we were supposed to talk about the national ADR policy that was recently released. We have not tackled that. There is private mediation, which is also upcoming, and possibilities of its enforceability. That is also a topic that we need to discuss, and much more. Burhan asks, thanks for the arrangement and discussion. Where does appellate mediation start? Does it currently apply to decisions at the Court of Appeal and upward, or even on first appeals? I think, Your Lordship, I think when you answer this, you will also give us your closing remarks so that we don't hold the participants much longer than we had promised. And then we will close the session.
I think the principle of alternative dispute resolution, and especially mediation, is that you can settle at any time. There is no start and finish. You can settle at any time. We recently concluded an amazing labor dispute where the matter came from the labor court, came on appeal to the Court of Appeal, and a decision was rendered by the Court of Appeal. And after the decision was rendered, the parties filed a notice to appeal to the Supreme Court. But at the same time, they made a request to the mediation registry for appellate mediation. I don't know if people on the call are getting this. It may be a little mind-boggling. In other words, the Court of Appeal had made a decision, and one of the parties was unhappy with the decision and had filed a notice of appeal to the Supreme Court. But the parties still came to us and said, look, the Court of Appeal has confirmed the decision of the High Court. And for the staff who had been fired, this is how the Court of Appeal has. I don't think the Court of Appeal enhanced the monies that had to be paid out for the workers that had been fired. But the company that had fired them then sought to sit with the workers and said, okay, we have lost at the High Court, we have lost at the Court of Appeal. Let us do a deal. Give us a rebate and we pay cash now. And every worker took it. Every worker took it, and the notice of appeal to the Supreme Court was withdrawn. So it can take place at any time. I'll just say a quick one for the ADR policy. The ADR policy has been approved. That is going to lead to the ADR Act. So I think members on this call and the rest of the law society should be watching out for the bill, the LDR bill. That one is coming. And this is very much in line with what has happened in Kenya. So please be alive to the ADR Act of Kenya. Actually, I'm not too sure it has passed. I'll correct myself. The ADR bill of Kenya, because that's the same process that has coming. And what's very important about the ADR process, it is also going to bring on board the AJS, the alternative justice system that the Ugandan judiciary is also bringing on board. So in terms of concluding, I've been following the comment section as well. I would like to say a very big thank you to the people who are on this call. I see a greater willingness to embrace alternative dispute resolution from the comments here. This is a big change. It's a fundamental change from what it was 15 or 20 years ago. And I think there is a new generation that is evolving of legal practitioners who are now really dealing with the real issues that bring conflict. So it's encouraging to me to just read the comments that are out there. I just encourage those who are on the call to embrace these innovations that are coming out of the judiciary, whether it is mediation, whether it is plea bargaining, and small claims. This is making dispute resolution a lot more efficient and more effective. So I congratulate you on that one. I know the courts are not exactly where they want to be, but I believe that these innovations will help improve that image. So thank you very much again.
Thank you so much, Your Lordship. I think we should have you again, because you're such a useful resource, and you are honestly the encyclopedia now on ADR. So I think type in the comment section if you want His Lordship to be hosted again, so that he shares more nuggets about ADR. Otherwise, I see comments. Many people would like to have you back. Many people would like to have you back. I would like to thank you, Your Lordship, for sparing the time and always being open to discussing ADR. You're such an inspiration to those participants who have not yet embraced ADR. And I think this is just the beginning of the conversation. And I hope that we can have more conversations like this. For those on the call, I would like to say thank you so much for being here. And I would like to say that mediation is not about who is right, but it is about what is right for those who are involved. It is not about you, the lawyer, but it is about the disputants and the parties to the dispute. Before I leave, I would like to say thank you to the Muslim Arbitration and Mediation Center Uganda, and to the Uganda Law Society for this beautiful collaboration. And I hope we can have many more after this. And yeah, from me, it is bye-bye. Have a nice evening. I hope we can have more conversations like this. Thank you so much. Bye-bye.
Yeah, bye-bye.